like to welcome Phoebe Okowa. Phoebe is a Professor of Public International Law and Director of Graduate Studies at Queen Mary University of London. She previously taught Public International Law, Constitutional Law and Private International Law as a member of faculty at the University of Bristol. She's held visiting appointments at the Universities of Lille, Helsinki, Stockholm and WSZB Berlin Social Science Centre of Global Constitutionalism and has lectured for the United States at his regional course on international law for Africa. In 2011 and 2015, she was Hauser Global Visiting Professor of Law at New York University School of Law. An advocate of the High Court of Kenya, she's acted as counsel and consultant to government and non-governmental organisations on questions of international law before domestic and international courts, including the International Court of Justice. In 2017, she was nominated as an arbiter to the Permanent Court of Arbitration at The Hague. She's also recently been elected to the International Law Commission for a 4-year term.
5? What?
So, yeah.
Okay. Well, thank you very much, everyone, and thank you very much, Jenny, for that generous introduction. I have to say, for me, I'm always happy to be back to Wadham. Honestly, genuinely, I mean it. I was here last summer at the height of the pandemic, and the most striking thing for me was that there were female porters. All the porters I encountered were female, and maybe that's not that radical. But in all the time I was in Oxford, not just at Wadham, but all the Oxford colleges, there were no women. And I suppose some of these things are just entrenched because I'm sure nothing has happened since colleges started hiring women porters. Security is not lax, it's not a problem. But that just goes to show how sometimes these entrenched traditions have absolutely no rational basis at all. But it was a world where the presumption was that the porter was male. So that was reassuring. It was very pleasing when I came with my daughter, and she couldn't understand what I was talking about, like we were visiting some medieval institution, but there you go. So I was asked to talk very briefly for about 20 minutes about the trajectory of my career, essentially from Kenya to Oxford to an academic career, and most recently being elected to the United Nations International Law Commission. And that, the last one, has some significance, although as lawyers, International Law Commission is a technical body. It's charged with the progressive development and codification of international law. Hardly the stuff of headlines, but there's something very peculiar about this institution. It's the premier UN body that is charged with the codification of international law, set up as a subsidiary organ of the UN General Assembly in 1949. Since 1949, it has had 229 members. And of those 229, only nine have been women. So in 75 years, there have only been 9 women. And the first women were elected to the commission in 2001. And since then, it's a slow progress. In this election, there were 8 women nominated. And we hope that all 8 will be elected. But only 5 were elected. So there will be 5 in the commission. And 5 is also the largest number in its entire history out of 34. So I think that in itself did raise some significance. I also will sit on the commission as the first elected member from the African Regional Group, and only the second woman to have been nominated. So beyond that, so I was asked to talk, and as academics, we are not really used to talking about ourselves. This has been a really new skill for me. And remember, we sound like dinosaurs, but we grew up, and I became an academic in an era before the social media. So the one thing you're most uncomfortable about is anything that smacks of self-promotion, or you let others do the talking and you do your work, and you let it quietly, either your work quietly speaks for yourself or avoid any situation. But I increasingly became comfortable with it because that's what you do when you're campaigning, you sell yourself. I spoke to 165 UN members. So in a sense, in talking about the trajectory of my career, there was really nothing preordained or predetermined, either that I would come to Oxford, that I would be an academic, that I would get into the International Law Commission. My parents were both teachers, and I grew up in a very patriarchal society. In fact, all my grandparents on both my parents' sides had no formal education. So there was already progress in the sense, the fact that my parents had education. My father rose to be a school headmaster. by the time I went to university, there were a few good things that happened. I was born in 1965, crucial in the sense that I was born 2 years after Kenya became independent. So I was born into a very confident independent state where actually, at least in theory, the sky was the limit. There were no formal limitations on what I could achieve in educational terms or what I could do. But there was also one sense in which it was very good for the confidence building of a young girl who is ambitious, who's studious, that we were part of a group of students who were inculcated into a decolonized curriculum. People talk about decolonization now, but those of you who've probably read the Kenyan author Ngugi wa Thiong'o, Ngugi wa Thiong'o came up with a very radical idea that a new confident nation had first and foremost to decolonize that curriculum. And in fact, he called it Decolonizing the Mind. So I was a generation that never studied the canons of English literature, but I studied literature in English. Writers writing in English from the Americas, from the Caribbean, from West Africa, translations in English, the Kuli, Grapes of Wrath. But the whole idea was that you had to confront, you had to have a window into the world beyond a narrow English curriculum. So a generation before me would have just studied Shakespeare or Hardy. But we did those, but in a much broader context of a decolonized curriculum. Why was this significant? It just meant that by the time I went to school and throughout university, you grew up being a reasonably confident individual in who you are, and that was the whole purpose of this education. But then I also went to a university which was predominantly male. The majority of students when I went to the University of Nairobi were men. All the academics, all the lecturers, from the most senior professor to the most junior, were men. The only female members of that faculty were secretaries and cleaners. So that was the world into which I grew up and studied. In one sense, I had parents who believed in me, and I also had teachers who absolutely believed in me, who had the knack to tap potential and support that potential irrespective of gender. So it just goes to show that even in a very conservative society, even within those constraints, individuals can make a difference. And really, that's how I ended up coming to Wadham. So the Wadham story was, so I graduated from the University of Nairobi in 1987. Since I'm told to talk about myself, I will say some of this. Like everyone else who came to do the BCL then and now, I graduated at the top of my class with a first-class honors degree, and then got a scholarship to come to Wadham to study the BCL. I'm always asked, why did you choose Wadham? Why Wadham, And I'm always tempted to invent a story that I spend a lot of time poring over Oxford prospectuses and trying to think which is the most progressive college to go to. Wadham's progressive narrative is what swayed me to come here. Or that it's a college that was founded by a woman. And quite frankly, none of that's true. Quite simply because this was before the age of the internet. And even though I did look at battered down prospectuses of Oxford colleges at the British Council Library, it made nothing to me. Balliol, St. John's, Oxford. The only reason I came to Wadham was that two of my tutors and the founding dean of our law school had been to Wadham and thought the world of Wadham. H.W. Okothogendo, whom you know, had been to Wadham, was Peter Carter's student. And as far as he was concerned, the only two things worth doing in the world, one was to go and do the BCL, because it was the most challenging program. And if you're going to do the BCL, you go and do it at Wadham, because then you'll be taught legal history, which I never did, or Roman law by Geoffrey Hackney, or you will have Peter Carter for conflicts of laws. So that was the story I was presented with, and I applied to Wadham. In fact, I don't think I ever applied to any other college. But it's something I haven't regretted, because that progressive narrative, in my case, proved to be true. Not only was the college then, I think it still has a very progressive reputation, but a lot of my own political education happened here in Wadham, quietly observing questions of tolerance. Not only, remember, I had come up, not just a conservative society, but a one-party state. So the idea of a student voice, of protests, I remember working in the library, and there was always a book that ended with Free Nelson Mandela, even after Mandela was free and was president of South Africa. It was the interactions I had with Chinese students just after Tiananmen Square in 19 Holywell Street, which really informed that practical education, which of course I didn't get in the St. Cross building or in the tutorials with Peter Carter. So for me, it was an awakening. It was a window into the wider world. I saw more African students in Oxford than I had in Nairobi, not necessarily in Wadham. Wadham itself was not very diverse in that sense. I mean, I think in my time here on the BCL, I was the only African student. There was a very able and exciting friend who went on to be an academic at the University of Jamaica, Susan Fox, whom Jeffrey taught the law of trust, and we had a lot of conversations about. So that was the context in which I came to Wadham. But even more interesting is, how did the founding dean of our law school end up coming to Wadham? I think that's much more interesting because it reveals a lot about what we've lost in terms of university academia and in terms of how we engage with the rest of the world. So in the late 60s, Professor Ian Brownlee, he wasn't a professor then, a Wadham fellow, who I am told was a committed communist and a very proud and out member of the British Communist Party, was on sabbatical. And in the late 60s, if you are radical and a communist, you went to Tanzania because that's where Julius Nyerere, the founding father of socialism, was president. So Ian Brownlee left Wadham and went to Dar es Salaam, where the students fondly referred to him as Comrade Brownlee. And so Comrade Brownlee, at the end of the year, encouraged two of his brightest students to apply to Oxford, and specifically to Wadham. So that's the story of how both Okoth Ogendo and Kamau Kuria, who then both taught me, had come to Wadham. Now, what is interesting about that Brownlee story was, at least in UK academia now, you can't just decide that you would like to go to sabbatical to experience what the world looks like if you're an academic in Vanuatu or in Tanzania or in Ghana. You know, all our sabbaticals are tied to very controlled, referable agendas of what you must produce at the end of the sabbatical period. So that story you almost can't replicate now. And I think it's lost because we've moved forward towards what is essentially a very transactional relationship in how we engage with the rest of the world. I think students are encouraged to apply, they're encouraged to come because they are a source of income. And academics may engage in research projects in a context in which it's of value to the institution in a very transactional and marketable sense. So the idea, and I think something is lost in that, where you could just go to a foreign institution and teach for a year and experience what does it mean to be a local academic working there. And it wasn't just Ian Brownlee. I think William Twining went and Patrick McCausland. There's a whole generation of British lawyers who would go in the Commonwealth precisely for that reason. And I have to say, it's something I've always been very fascinated, thought about doing, but the constraints are essentially what they are. I am on sabbatical next year, and I can't do anything other than a very constrained project of what I must produce at the end of that sabbatical period. So in terms of future engagement, I would love to see a world where that was a possibility, where you could have meaningful exchanges on the basis of real equality, where academics could go anywhere and bring students or encourage students to come. Or Wadham students could go to the University of Nairobi, not so much because what they have to bring back to Wadham, but because that in itself would be an educational and a very meaningful experience. But so then what happened when I came to Oxford? I mean, as I've said already, I did the BCN, and I'll talk a bit about more of that, but let me finish with the Brownlee story. So this radical comrade, you'd ask, what then happened to Comrade Brownlee? Comrade Brownlee taught me international law, law of the sea, and he was also the supervisor of my doctoral dissertation. But I have to disappoint you that, in a sense, it's probably the dilemma that all radicals face when you're in a very conservative profession. Because the man I met when I came to Oxford in 1988 was very much an establishment figure, a very successful lawyer working for states. And by the time he retired from Oxford, he was knighted and he had silk. So I think he smiled when I asked him whether he was still Comrade Brownlee. He never denied. But I think it's also telling whether you can maintain these ideals and radicalism in the context of a profession that's very conservative, and in a context where to be taken seriously, you probably have to be more conformist. I don't know, maybe. But that was the context, and we never had much of a chat about Tanzania, about the student riots where the students held all members of staff hostage, and the only person who was released was Comrade Brownlee, because he was the only one whose ideas and aspirations were in line with their own. So Daniela, you asked me the Brownlee and Wadham story. That's one aspect of it. I am very grateful to Wadham, and I'm not saying this just because Jeffrey is sitting right in front of me, and in one sense there's nothing to gain from saying this now. I'm not rewriting history, but it is true. I was very well supported. I'm not sure, Sandy, how much time you have for your students in terms of, the academic culture has changed. We were just talking about the one-to-one tutorials. But I was not only supported during the BCL, I benefited from the college hardship fund, for instance, which I must confess, I was never asked to pay back. I have paid it back, and I paid it back ages ago. But what was so reassuring about it was the very generous spirit in which it was given. It was quite clear that I had run out of money and I hadn't finished my thesis. And I was given money out of the Warden's Hardship Fund. And after a period of time, I started paying it back in installments. So that's why on the few occasions when I have anything to give back, the Warden's Hardship Fund is the first one I think of. And I also think about it in the context of which there were no strings attached, there were no pressures around it. There was no long story about an application form. I hope that's still the case. It was a very straightforward, simplified form that you don't want to humiliate people just because they have financial need. So for me, that has remained an abiding act of generosity that I take away from Wadham. The other reassuring stories, and again, I have no intention of putting any pressures on the tutors here. Jeffrey, I have to say, I have not been able to repay that. But when I came to Wadham, I was pretty homesick in my first year and the first semester. And around Christmas, I met Jeffrey on the front quad or the back quad, I can't remember. He said, "What are you doing for Christmas?" I said, "No plans." And he said, "Well, do you want to come and spend Christmas with my family?" And I thought, "Oh, that would be great." So I spent my first Christmas with Jeffrey's family, with Lucy, with your mother-in-law, and I think I was supposed to stay one night, but I was so comfortable I spent two. So I am always very conscious that I need to repay this back, but only as an adult with my own family do I now appreciate how much of an impulse, an act of generosity that was. But that was the climate, that was the Wadham in which I came to, in which I felt nurtured. The moment I walked through the Porter's Lodge, whatever other pressures I had elsewhere in Oxford, I always felt really comfortably at home here. So I think that's sort of the trajectory after we get to Wadham. My tutors encouraged me to apply for academic posts, and they were supportive of me. Peter Carter had retired by then. I was encouraged. We had long conversations about where to apply, how to apply, whether to go to the bar. And so in that sense, I never felt at any stage that I was left on my own. Remember, I was a foreign student from Kenya. Coming to Wadham was also my first act of coming overseas. I had never left Kenya. I was 23. So in some sense, although very committed academically, and also I had built very strong bonds with my fellow students, as a strong element of comradeship. For me, that support from the tutors was crucial, and it was crucial to the subsequent trajectory of my career. I spent years at Bristol, I applied to Nottingham. In all those, I was fully supported. I remember having conversations with Jeffrey, with Peter Carter in the common room about how to handle the interview. And again, Sandy, no pressure here, but that was a very different world of that kind of very deep engagement. They just didn't care that I got a degree. They cared in what happened to me afterwards in a very detailed sense. But again, I'm sure much of that is lost given the marketization of higher education, the pressures tutors face. I don't think, I try, but I'm not sure I could be the kind of tutor that I would want to be in the climate in which I have to teach at Queen Mary. So much of my subsequent career was spent at Bristol, and then I went to Queen Mary, where I've been a professor of public international law and mainly teaching public international law and also teaching a variety of courses on the LLM. In between, I've done a significant amount of work now, advisory work for governments. And that also proved quite crucial in my campaign to be elected to the International Law Commission. Because one of the interesting things about the International Law Commission is that states expect you to be a jury consult, extremely knowledgeable in matters of international law, but they also see international law as a practical discipline. The International Law Commission is not an academic research institute. It is there to serve the practical needs of states. So one of the questions that they're really interested in is, do you have any governmental experience? Have you done advisory work for governments? And part of the problem is much of the advisory work is also done by men. So that also partly explains why women they don't get nominated, but they don't fare well in elections either, precisely because you can get knocked on by being told all those questions, that this is theoretical, this is all academic work, have you done any practical work? So those are some of the challenges that you encounter in a real world context as well. But again, the only advice I would have is each of those challenges, you just have to confront them, take them head on, and form alliances there with progressive colleagues, progressive lawyers, progressive states who would be prepared to champion your cause. But as they say, no one gives you power or opportunity. Sometimes you just have to take it and knock on doors and ask to be supported. So that's, I think, is the story of Phoebe Okowa from Kenya to Wadham, to Queen Mary, to the International Law Commission.
Sounds perfect. Thank you very much, Phoebe. Can we all give a round of applause? So now Angel will ask some questions, and then we will open to the Q&A.
Towards the end of
Yeah.
this event. So thank you very much, Phoebe, for very honest sharing. It's very great to hear how Wadham has been progressive and a welcoming environment all along. And we're curious to know if you think that representation in international legal institutions can be improved, and what can be done to improve representation in those very established institutions?
Right. That's a really difficult question. The reason why it's difficult is in international law, there are a lot of qualified women lawyers. There have been half the members of the International Law Commission like me, have an academic background. They are professors of international law and they're jury consuls. And the international law has always been a very academic discipline. I can name professors of international law even at the time when I was doing the BCL, And so the question is, why has this not translated into membership within the International Law Commission? Quite frankly, that record is one you can't even find within national systems anymore. I can't think, maybe apart from Afghanistan, I can't think of any institution where you would, over a period of more than 75 years, only have 9 women and 229 members. So there's a real systemic problem there, and we had a lot of soul searching about what can be done. First, states need to nominate more women, because unless you nominate more women, they won't get elected. It appears that even when women are nominated, their chances of getting elected are still substantially less than that of men. The US has never lost an election on the International Law Commission, but this year they did when they had a female candidate. So it's a very difficult one. From my point of view, is that maybe some of the practical suggestions is to amend the charter and make, so for instance, some of the newer UN institutions like the International Criminal Court actually stipulate that no more than a certain percentage of the membership will be of the same gender. And to me, maybe that's the only way to go about it, because that will force states to nominate and consider women. That's one. Now, of course, amending any UN Charter provision, because the International Law Commission is a subsidiary organ of the UN General Assembly, is going to be difficult, because the same entrenched interests would probably make it very difficult to push through an amendment. So one other option, which a lot of us are now thinking about, is really a lot of outreach programs writing to women who are qualified to ask their governments to consider nominating them, not just wait to be nominated. And the conversation is to start it now, because the next election is in 2027. So if you wait until 2025, maybe they already have tapped someone that they're going to nominate. Some states already have very progressive measures about dealing with this, like the Netherlands. They have a committee which essentially advises the government on who should be nominated. So it's a very objective process and a very objective exercise. And the membership of that committee is also determined on very defensible objective criteria. They are professors of certain universities, members of the Supreme Court, and members of the Court of Appeal. So the Dutch government is not just going to tap someone without this committee considering all questions, including questions of gender parity. So for those states that have constitutional provisions, such as Kenya, where gender parity is now a requirement in all public positions, invoke that. In a sense, I did say, well, gender parity is a fundamental value in the Constitution, but all the members of Kenya's nominated in all UN bodies have been men. So you have a conversation around that, but it's not going to be easy. I think it's going to require all varied approaches. Women need to put themselves forward. Men need to consider what they could do to improve the situation, and not just in terms of appointment to the ILC. It's also things like, who do you appoint to arbitration tribunals? Who do you appoint to commissions? Because, as I said already, states want individuals who have practical experience in governmental work, who've done advisory work. So even if you're nominated as a very eminent professor of international law in Oxford and you've not done advisory work, states will say, well, this is too academic. We want people who see international law as a practical project. The commission is there to serve the needs of governments. It's not an academic research institute. But I think it's not going to be easy, because at the last election, we really thought that all the 8 nominated women, remember the commission has 34 members. It was not a big ask to essentially elect all 8, and all 8 were very qualified. But again, it didn't happen. I mean, regions like Latin America have never had a woman, and all the Latin American members, they've never even nominated one, are all men. So.
That's very true, and we do want to see more improvements in the future. So perhaps looking back, so you've taken roles of professor, advocate, arbiter, and an advisor to governments and NGOs, and soon to serve on the ILC. So how do these roles you've taken up over the past years differ from each other?
So they're all very different, and they all come at very different stages. So much of my advisory work, I should tell you, is very recent. States are very conservative. If they have a case, they always want someone who's done the case before. You're not going to take a risk with an unknown professor, however eminent in the academic field, in a matter of, say, maritime delimitation. What if you lose? So that's always a problem. But these roles are very, very different. Teaching and research is very different from advisory work. Advisory work is much more practical. It's very much a lawyer's work, and the skills you bring to that, it's in part informed by what you do as a teacher. And what I found most useful, and those who are international lawyers should bear this in mind, is not the specialization. The techniques, methods, processes of lawmaking is essentially what you engage with in litigation. In the last case we did between Kenya and Somalia, all it boiled down to, which I had to deal with, is whether or not Somalia had acquiesced in the boundary line that Kenya was proposing, which was much more generous to Kenya than the rules of international law dictated. And so all we spent time on is the question of acquiescence as a matter of law. And so it wasn't even the substantive law of the sea as such. It was just general rules of international law in acquiescence and whether there are exceptions to it and whether or not you can actually acquiesce in a process that contradicts a substantive treaty obligation that you've ratified. So that was very interesting. And it all varies. Some of the advisory work I've done is in the context of being an expert on a question of international law. And I should say for lawyers, I would say stick to advocacy. I have to say I never enjoyed being an expert, being grilled on it, because you're used to having your word taken in an advocacy context and you're grilled on. But this was a question of treaty interpretation on the Montreal Convention on air travel. And I was brought on as an expert to advise a lawyer in the context of domestic litigation, that where the Montreal Convention conflicts with human rights obligations, specifically the obligation, the Convention Against Racial Discrimination, the Montreal Convention essentially dictated that the only remedies you can get, the exclusive remedies, are those provided for under the Montreal Convention of Air Travel. And the question was whether or not the state in question could contract out of its obligations under human rights treaties. And that involved a question of relationship between treaty regimes and whether the treaty in question incorporated overriding norms of international law of jus cogens. But so far so good. I was pretty confident. This is, every public international lawyer should be able to advise on questions of treaty interpretation. I don't have to be an expert on the Montreal Convention. I was asked to advise on relationship between treaty regimes, successive treaties, and how you interpret them, treaties incorporating erga omnes obligations vis-a-vis treaties incorporating standard obligations. Of course, as you can imagine, the air industry would not be interested in this. The exclusivity of the Montreal Convention is what protects them. The only remedies you can get is those dictated under the Montreal Convention. So I was facing a barrage of lawyers, paid vast sums of money. I was doing the work pretty much pro bono by Air Canada. And I was grilled as an expert witness for almost 7 hours with breaks in between. So I made a mental note that I think next time I may decide that being an expert is not what I want to do, precisely because of what you're likely to encounter. But the matter is pending now, I think, before the Supreme Court of Canada.
It's very interesting to hear about very memorable cases, such as this one on the Montreal Convention. So we're curious to hear how, if there are any challenges that you encountered in your career, and how do you overcome them?
So, wow, okay, no. I think some of them are practical. I'm an academic, but I'm also a mother, and it's very hard balancing looking after children and doing all these multiple things. In fact, the temptation is just to really stick to your academic work. This is also another reason why advisory work becomes very difficult for women at certain stages of their career. The International Law Commission, for instance, meets in Geneva. They meet over 12 weeks in a year, 4 weeks at Easter, 8 weeks over the summer. Have always asked that if you have young children, what exactly are you required to do with them? And, also, it really just doesn't make sense. I'm keen for women not to start raising that question, perhaps get in there and change the rules of how you meet and how the working methods. But that really is a practical constraint. And my children are adults now. They are 19. My son is going to university in September. My daughter is already at university. I can now take in some of these roles. But as a practical matter, I'm sure there are many stages in my career where I would probably not have taken them or wanted to be considered. I think others are much more problematic in the sense that my entire career has been in the UK. And there are profound challenges when you work as a minority in a predominantly white institution in terms of the composition of staff. And I've always wondered whether those who do the hiring, who make these decisions, reflect on the sense of isolation that are felt by minorities in universities. I think there's a lot of talk about students, but I'm never sure there's enough talk about how you support members of staff who may, over very long periods of time. I've been at Queen Mary now since 2003, and Shazia and I were colleagues, and it is not a diverse department in an institution where, unlike most UK institutions, almost 60% of the students are what you'd classify as BME. The other reason why it's left me with a deep sense of introspection about what can be done about this is because how do you manage the aspirations of these students if they will never see anyone who looks like them in a position of authority or as an academic or in terms of even speakers that you invite? So a few years ago, I started a series of lectures, which Shazia and I did together. And the objective was just to invite speakers who would give our students a perspective on what the world looks like when you're not European. They didn't have to be a person of color. In fact, one of my first guest lecturers was Professor Phoebe Okowa, who had done some work in Haiti during the cholera epidemic and the very difficult situations he had in trying to get the UN to assume accountability for that cholera epidemic. So again, that was where we got Tracy Robinson. Shazia, you got someone else? And it was really interesting. Students we'd never seen ask any question were suddenly very comfortable in this environment, in this context. We got...
We had lots of students of SOAS turn up, actually, do you remember?
Yes, yeah.
Some students from other university colleges, London colleges.
Students in my class that I'd never seen raise their hand or ask any question. I remember when we had Tracy Robinson, who was then the president of the Inter-American Commission on Human Rights, and she came to talk about gender and bodily diversity in the Inter-American system, which is very interesting, and also talking about her own struggles as a female lawyer in a very conservative society, religious society like Jamaica, taking on the project of gender and bodily diversity within the system of the Inter-Americas and the challenges she faced. So I think for me it was also the fact that students could relate to this, that these were not just abstract ideas, but also that they could aim high, that there were people who had a background similar to them, who looked like them, who had overcome obstacles to get into a position of leadership. So for me, those are some of the practical challenges. The other thing I've encountered as an international lawyer, less so now because I'm kind of quite assertive, and there were very reductionist assumptions about I must want to do something about refugees in Africa. And I am a public international lawyer. I'm interested in the methodology, the techniques, questions of public international law in a global context, but also I could do regional stuff, but I was not prepared for these assumptions. I was getting invitations to talk about Afrofeminism and international law, and I thought, I haven't written anything on feminism, Afro or otherwise, and this is the only thing they wanted me to contribute about. And I remember saying, actually, I want to talk about the forgotten women of international law. I want to talk about Christina Marek, who wrote on the questions of identity and continuity of states. And the book, I think, is very fascinating. Oh, no, we don't want you to talk about that, but can you talk about Afrofeminism? And I refused. And I got a lot of rejections. I got a lot of invitations of that kind. You're pigeonholed. And there are all sorts of assumptions about what your competence must be. And quite frankly, it's just insulting.
Yeah, that's very true. So if you are to point to some specific areas of international law that you think would be more relevant in the coming decade or in the coming few years, what areas would you highlight, and do you think they are very significant to the development of this area of law?
I think the most consequential question facing international law and international lawyers is the question of climate change, without doubt. And that's a priority area and how we take things forward. The International Law Commission, which I will officially join in January, that's when our term starts, is already facing some issues around that, whether questions around sea level rise and the potential disappearance of some states. The consequences are really stark and what to do about it. But it also raises very profound questions about the whole body of international law, because if these states disappear, what are the implications for questions of statehood, for questions of national identity, for questions of self-determination? What are we to do about displacement? The whole body of law, of international refugee law, is in a flux. And also, how should we respond to these threats? So the conversation, as you know, has already been going on within the context of the Paris Agreement. But it is an ongoing conversation, whether or not we should now use litigation strategies to essentially hold states to meet their commitments under the Paris Agreement, and if so, in what forums and in what context. So both within the context of domestic law and international law, that for me I think remains the most important and consequential question, not least because it's right there.
Yeah, that's certainly a very pressing issue that we face currently. And on the topic of the ILC, so we're curious to hear about how you got elected. How was the procedure like on your election to the ILC?
So how did I get elected? For years I have sent signals to the Kenya government, to anyone that, would you be interested in nominating me to the International Law Commission? But they had people they nominated. Most of them may not have been. Are you still recording? Anyway, so since I will stand for re-election. So essentially, but then I started doing a lot of advisory work for the Kenya government in the context of the litigation, maritime boundary delimitation with Somalia. So I got to know many of the decision makers. I was an international lawyer, male or female. They didn't have any other competitor who they could say in substantively in terms of international law, this is the person we would like to nominate. So I just asked to be considered, and I sent my CV, and I sent a very long letter asking whether or not, because they said this time they were going to have an open competition, and they asked anyone who was interested to send a letter to the Office of the Attorney General and the Solicitor General highlighting why they should be nominated. And in fact, this was a gift, because finally there was an open and transparent process, and that's precisely what I did. I sent a letter, and because I was already doing a lot of advisory work, they couldn't really doubt that I had the practical side as opposed to just academic work. Of course, there were other challenges. The fact that I've spent most of my academic career in the United Kingdom. And the other thing is the International Law Commission is a technical body. It's not as sexy as the WTO Secretary General or the UN Secretary General. And just as my nomination went through, Kenya decided that what they were really interested in was the Commonwealth Secretary General. And so all the resources and the efforts of the diplomats were directed towards that. And, so that was, they were going to support me, but, the International Law Commission, it didn't become much of a priority. A lot of good things happened to me, though. One, I was co-nominated by the United Kingdom. And that didn't mean the United Kingdom was spending any resources on my nomination, but it was a big boost for my campaign. And crucially, the UK lawyers who are in New York and in the Foreign Office in London are people I knew. So suddenly, I had a support network, people I could call, people I could ask on how I should strategize. And there were a lot of Kenyan diplomats as well who thought that my nomination was a very progressive thing, that they were going to go out of their way to support me, whatever the official position was. So those were two, and a huge network of friends, of international lawyers, BCL colleagues. Most of my colleagues in the BCL ended up being very successful in the Commonwealth, in Australia, in London. So I suddenly joined LinkedIn and was able to tap into this vast resource of, Oxford connections, actually, just to put it quite straightforwardly. And they were very, very supportive, including Tracy Robinson, whom I mentioned earlier, she did the BCL a few years after me, but because she herself had been elected to the Inter-American Commission on Human Rights, she had a very big network within the Caribbean states. So that was it, a lot of state support. You can't succeed without the state being behind you, because a lot of decisions about who votes for you are not even dependent on your credentials as a candidate. There's a lot of horse trading, to use the UN language. We vote for you and you vote for us. So half the votes maybe came that way, and the rest of it was you also have to do campaign. I spoke to 165 UN member states, either through Zoom or on face-to-face talks in New York. So you just have to put yourself out there and say what you're going to do for the commission and what you have to have an agenda.
Thanks very much for a very honest sharing, and we all share the excitement for your recent achievement. And perhaps one final question for me is, as part of us in the audience are students, so if we want to start a career in public international law, would you have some tips for us as beginners?
So fast, write very good essays and attend all your tutorials. But seriously, much more importantly, I think to be a good public international lawyer, you need to be a good lawyer. Many of the skills that you will require either in a litigation context or in the context of advisory work are legal skills. And I draw a lot on administrative law reasoning, on tort law, much of the law on state responsibilities, the law of negligence writ large. So I think it's very hard to be a good public international lawyer without first knowing the basic principles of law, or being a very, very good lawyer and writing well, writing effectively. And then having mastered that, the next thing is I think you need to take a very specialized interest in public international law, either in terms of graduate work, which I think you're already thinking of doing. But it is much easier to be a public international lawyer if you're a good lawyer first. It's much easier to pick the techniques, principles, and methodology of public international law rather than the other way around. You can't just become a public international lawyer who has no formal legal training. People say they are, but I think it's much harder that way, certainly in a very practical context, I found.
Yeah, that's very honest advice. And Jeffrey is going to make a comment.
Phoebe, do you mind if I pick up on that? I once had coffee with Ian when he was in the middle of a boundary dispute.
Right.
And he's Ian Brownlee. And he was, I think, raging would be a sort of nice way of putting it, about the representatives from a major Western state, member of NATO, won't name it, but it's across the Atlantic Ocean. It's got 50 constituent states.
Right. We can work two and two together. They also like guns. Right.
But Ian said that the trouble with this case is we keep getting lost. He said that the international lawyers they've gone into university, they've done no property, they've done no contract, they've done no tort, and they completely fail to see the importance. And he said, and I'm really pleased to hear you reinforce this, because he was furious about it. He said to be a good international lawyer, you cannot not know about property, contract, tort, the basic elements of the private law. So although it's a public law topic, so I'm pretty well guessing that you would endorse that.
I would absolutely agree with that. And in fact, this became much more obvious to me when I started doing advisory work, and that the skills you needed were basic legal skills, the training as a lawyer, and subconsciously that came back. And also because in many areas, the principles of public international law are not that developed. You have to go back to first principles within administrative law, within tort law. So yeah.
And if you're doing boundary disputes, you need to be a good drawer at it.
No, I can assure you you don't. You're surrounded by very well-armed cartographers. All you need to tell them is these are the legal principles. Can you plot where if we are to apply this principle, where should the boundary be? That used to worry me a lot, that, which of these many competing ideas, how will I draw the boundary? But I realized that wasn't my headache.
Great. So now the floor is open. If you have a question, raise your hand. Well, maybe let's take it in two at a time. So first, Ayako.
Thank you, Janina. And thank you for the fantastic talk and then advice to students as well. My name is Ayako Hatano. I'm a first-year teacher student here in Oxford in international law. And then I did my LLM in NYU.
Okay.
Sent me to the IMC as a fellow and work with I had a privileged opportunity to work with Mr. Salman Wood, over there. So I'm so happy to feel some connection with you. My question is, I'm so curious about what you think about the role of IMC, because some people argue the IMC role was bigger before, but in a history, but now it is some kind of the power or role of IMC there are many drafts, but which is not really getting into convention or treaties. But having said that, you said, as you said, there is a lot of like important progressive topics in IOC, especially like environmental issues. So there's a lot of I think spaces for IOC to contribute with a technical expertise. But like there's a lot of some politics going on in environmental areas. So what do you think about the role of IOC, like especially in this kind of complicated era?
Thank you. And you,
Thank you very much for sharing. I'm Joseph, a second-year law undergraduate at Wadham as well. My question is relating to, quite similarly, what you foresee the work of the ILC to be. And I think one big problem that you flagged was not only an issue of diversity within the ILC, but when you think about how international law itself, customary international law, develops from state practice and opinion juris. And a big problem behind the development of CIL is that it's very Euro-dominated and American-dominated, because those are the states that publish and make accessible state practice and opinion juris. And especially, I think, in nascent areas of international law, like, for instance, international law in cyberspace, or the more recent areas of environmental law, we see that, for instance, Africa is an area that's not necessarily as well represented in the state of customary international law. And I'm curious how the ILC will work to, for instance, increase accessibility, translation, for example, or even just the proliferation of state practice and opinion juris from underrepresented states.
Both your questions relate to very live questions, which were raised countless times by states themselves, by constituencies that we had to engage with. Part of the problem, there's a feeling that the golden era of the ILC is over, that the successful projects were the Vienna Convention on Law of Treaties on Diplomatic Immunity, that there was a time when essentially there was a vacuum between the United Nations and now. And the one idea is that the ILC is, as it was, scratching at the bottom of the barrel. That they have, they're looking for topics and trying to invent work when much of the work is either already done or being done by other bodies. So why should the ILC consider climate change or pandemics? Why not send it to the WHO? So there's a debate within the International Law Commission whether the commission should stick to large constitutional questions, which the argument is that that's what it can do well, mapping the area, codifying rules on succession, on law of treaties, and that it should leave aside the detailed technical topics, including climate change or global pandemics, or topics which successfully, for it to come up with either a draft treaty or a draft set of rules, will require political compromise. And that members of the commission are 34 lawyers whose expertise is law, and that no legal system would entrust its policy making to lawyers. You make the law elsewhere, you create policy papers in Parliament. You don't ask the Law Reform Commission to draft a draft statute in the draft convention. So one argument is that, that the ILC should essentially stay from either technical topics, political topics, topics that require compromise, and it should stick to the core constitutional questions where there's already a body of practice, where in fact it can contribute in synthesizing and bringing those body of rules together, and that it should stay away from new topics. The other side to this argument is to say that, even if some of these technical questions are best suited to technical bodies, climate change or pandemics to the WHO, one argument is that the Commission is actually the only body that can look at these questions within the broad context of other rules of international law. So if the WHO is drafting a treaty on pandemics, it will only be concerned with prevention, mitigation of the pandemic. It's not going to be very interested in large questions about human rights that arise from emergency measures and how you deal with those. It's not going to deal with large questions about how you incorporate obligations of solidarity or assistance. And if, in fact, there is no rule, someone has to provide a roadmap, a set. So the ILC may, and as you've noticed since you've been in the Commission, increasingly they don't come up with draft treaties. They will come up with a study group. And the object of the study group is to essentially come up with essentially a roadmap, a set of guidelines, which can then be handed over to political bodies such as the General Assembly. In fact, that's what happened with the Rome Statute of the International Criminal Court. That was an ILC project. But once the draft statute was produced, it was quite clear that to produce a treaty which would be acceptable to member states was going to require a lot of political compromises. So on the basis of this draft, a conference, a multilateral conference was convened where political actors could essentially iron those practical differences. So I think, for me, yes, I think the ILC has a very clear role in relation to the big constitutional questions, which is why one of the things I think they should take on now is one of the original topics that they've shied away from since 1949, and that's the criteria of statehood and the recognition of governments. Because the problems in that area have not gone away at all, and they're now being confronted with those problems directly in the context of sea level rise. What happens when these states disappear? Can you conceive of a concept of statehood in the absence of territory? And I think you cannot just single out and isolate the question of statehood of Pacific Island state without considering wider questions of statehood. There are a multitude of problems around recognition of governments, both ranging from the Taliban to Venezuela, and in all these contexts, or where there are competing claims to governmental power, where there is no repository of executive power. They're very difficult questions on how you deal with them. If the Taliban is not recognized and is subject to UN sanctions as a terrorist organization, what are the implications of that for aid agencies that would want to operate in Afghanistan? Are they paying taxes? Are they paying taxes to a terrorist organization? Is it a violation of a sanctions regime? Or does it come within some recognized exception? But the political organs have scattered around these issues and have tried to avoid them altogether. Or, questions of statehood, of which Crimea presents a classical case in point. What are the implications of acquisition of territory or extinction of statehood through illegal use of force? What are the long-term implications of this as a matter of international law? And I think these are all areas where the International Law Commission can actually provide some guidance in an apolitical context and perhaps provide a series of roadmaps or options for political actors to act upon. So I think, in a way, some of the very technical topics the Commission has taken on board, it's not been very successful at, like protection of the atmosphere. And that's because the work was already quite advanced. And really, 34 lawyers were taking on a very technical body, a very technical project to distill a series of rules when they had no technical expertise. But in other contexts, I think they can provide a very broad framework of, one, identify the problem, identify the policy options, and leave it to political negotiators to decide what would be an acceptable political compromise. And that's why I think the ILC should probably take on the question of global pandemics, even if the WHO is still considering it. I don't know if that answers your question.
Thank you so much.
So on the question of partial state practice and whether or not the codification is realistic, when ultimately all international lawyers probably come from largely a Western orientation. I think there was a project which said that is international law really international law by Athena Roberts. I'm sure some of you encountered this book. And their concern was not so much, it's not just a question of who are the international lawyers. So either they're Western trained, even when they're in Africa, Cameroon, or elsewhere, and that their orientation is the same, and that the only practice we ever encounter which informs international law is the practice of a very few states, so that you have, the British Yearbook always produces British practice on international, the United States. And that so, in a sense, we are all reproducing the same information as the basis of a codification of rules. So one argument is that that's why the International Law Commission comes in handy, because at least there's a very formal respect for the question of geographical representation. And actually, if you look at the International Law Commission projects, that was one of the original challenges when faced with all these questions that were being presented to them as rules of international law which are in need of codification. The first was to challenge it, rules of international law on the basis of whose practice. So the first was to challenge the codification project, that the practice on which this was being based was only the practice of a few states. And you need a forum like that, which is apolitical, which is neutral, to essentially challenge some of those assumptions around codification. And that's why there's been very little codification, actually. Almost all the projects have ended up being progressive development, because the new states, the Soviet states, essentially rejected what was being presented to them as state practice um, or, backed by opinion juris when it was just the practice of a few states. It's not perfect, but I have now seen the debate within the International Law Commission, either in relation to the project of use cogents or immunity from criminal jurisdiction, how much, say, African members of the Commission and Latin Americans of the Commission have tried to bring in a very different perspective on their concerns. And I can't think of any forum where they would have such a voice, a strong voice. So that's a risk, but the risk can be mitigated in part by having bodies such as the International Law Commission, I think, to bring to light other practices or other concerns or frustrations of states from the Global South as well, to bear on these projects.
I'm conscious of time, but also conscious that only 2 people had the opportunity to ask questions. So if it's okay with you, Phoebe, maybe we can do an extra round of questions and then...
I'm fine.
Yeah? Okay.
I'm not going anywhere. I'm staying the night.
That's great. Well, so any other questions on the floor? Please.
Yes,
Yeah.
I came in last, but I have a question, quite a personal one. I would like to know what the motivation is, given all the problems of public international law, that some countries, big enough, powerful enough, they break it flagrantly, no consequences or whatsoever, to the point that people even say that public international law is actually no law, they are just mere suggestions. And so if you're powerful enough, you can break them. Why would you decide to get involved? What's the motivation?
So,
Yeah, just,
okay.
Are there any other questions on the floor? It's your last chance.
That's a big question.
Yeah, well, maybe, yeah.
It's a very small follow-up on what you say. What can I say to students who are not privileged, who don't start with the good credentials? And you said it was hard as a teacher, and I was wondering, some of us are teachers and will be teachers. What is your line on it? Is your line like, I will encourage them, whatever the projects, to do whatever they want to achieve, or do you take into account, when you advise them, of the burden they may have to bear?
Mm-hmm.
And William, I think you also had a question, or no? Okay, yeah. Sorry.
So I'm tempted. Sorry, what's your name again?
Yao.
Yao. You know, Ian Branley used to say 2 things, what motivates him, and those both don't apply to me. But since he was a Wadham fellow, and since I think it's, one, he said that international law was like the M40. 90% of the time, it works fine. You know, the network of air travel. Even Iran doesn't shoot diplomats because they're very conscious of the law on diplomatic immunity. And even pariah states, or so-called pariah states like Libya. Libya, for instance, settled all its maritime boundary disputes with Malta, with Italy, at the International Court of Justice, hired lawyers because Libya knew that, you know, no foreign company, no oil company is going to invest in a space where there's disputed title. So the point is that in majority of cases, the network of relations that make us move around is essentially because international law works, right? But then there are spectacular cases where, of course, especially where powerful states are concerned, considerations of ultimate power and interest give way. And of course, Russia's invasion of Ukraine is probably what you had in mind, or the US invasion of Iraq. But in a sense, even in those very difficult positions, I think it's the language of international law that is being used to bring pressure to bear on these states. So in that sense, you know, Ukraine at the moment, as you know, is prosecuting Russian war criminals. And ultimately, that's the framework in which, difficult as it is, the discussion is taking place. What else? What are the alternatives? So, you know, I think in the majority of cases for me as an international lawyer, it works. Most questions of immunity are settled before the courts here domestically on the basis of rules of international law which have been implemented domestically. Human rights. Sometimes international law also exists as a promise on which to hold governments to account. And sometimes they ignore those rules. But ultimately, it remains a very viable tool for bringing pressure on states to comply. The question you ask that is difficult is what do you do when considerations of power prevail and when, you know, states are not prepared to yield to international law? And I guess that's just a systemic weakness that we have to live with. But international law also remains the only instrument that you can be can use to bring the parties to the negotiating table. So yeah, I don't think I have a straightforward answer to that, because that's the reality. We've seen it. We saw it in Iraq. We've seen it now. The attempts to create a tribunal. And in many ways, what's also worrying is the self-serving nature of international law. I'm sure most of you have noticed this in relation to Ukraine, that the very states that are calling for the creation of a special tribunal on aggression were the very states that invaded Iraq and resisted any form of accountability for it. So that kind of self-interest in the application of rules and its implementation is problematic. But they're being called out for that as well, that you can't set up a tribunal just for Ukraine. If you're setting up a tribunal on aggression, then it should be one with an jurisdiction over any and all future cases of aggression. You can't just single out that. But the language of international law becomes an instrument by which to challenge some of these assumptions. It was quite interesting to see Gordon Brown being told that he was actually a very unfortunate bearer for the accountability of Russia, because he was part of a government that invaded Iraq and they did nothing about it. So, in terms of students and how do you encourage them, and how do you encourage weak students to be interested in international law?
Oh, not necessarily international law and not necessarily weak students, but you were mentioning, if I understood correctly, students that would face more obstacles than others because of their color or for other parameters. So how do you do to encourage them in spite of these obstacles?
Right. I'm looking at Jeffrey because I think he has more experience. What do I do? What always surprises me, and as I start with public international law, because sometimes when students have struggled with law in terms of public law, I don't know whether that's the case in Wadham, that constitutional law is always a challenge for students in the first year, and then they have to do all the compulsory subjects. And I think there's an assumption that this sounds really woolly. I go and do international law and it's not that rigorous and I can get away with it. But in a way, then that's the challenge, because the outcomes, there's less certainty and predictability about the rules of international law. So what you have is a range of approaches to a broad range of questions. So you have to read more and you have to develop your arguments more. And then they're kind of taken aback by just how much reading they have to do. So I try and give a talk to students and just tell them, in relation to international law, to be prepared, to work hard, and that it will be rewarding if they really engage with the subject and make time to do a lot of reading and a lot of work around it. But how do I engage with students generally who are weak and who are not interested? I just try and encourage them to prepare and do the work and keep on the reading and do practice essays, because half the time part of the problem is really not lack of preparation, I think, because by the time they get to university, our students at Queen Mary come with 3 A's. I'm sure yours come here with 3 A stars. So they are capable of producing good work. The question is whether they prioritize their work, whether they put in enough effort. And I think the human instinct is to be lazy. Most people want good grades, but they don't want to work for it. So maybe I'm old-fashioned and old school in that sense, but I haven't done a Peter Carter and told someone to go out and read the case and come back when they finish reading it. But
you've been tempted.
I'm tempted, but I can see the consequences now. Is that you won't get away with that quite lightly, I think.
I would like to, on behalf of everyone, thank you very much, Phoebe, for the very insightful presentation on your life, your trajectory, on the future of international law. I think I certainly learned a lot from there. So maybe a final round of applause. And William, is this the final event of the given day?
This is the final talk, so thank you so much for everybody who's been part of them. And Phoebe, thank you so much for making the time to come and join us here. And hand over to Jeffrey.
Oh, me? Okay. Well, Phoebe, thanks very much. I think the older you get, the more you value time. And the young seem to think time grows on trees, and you learn as you get older that it doesn't. And I'm aware how much time you have given up to come to see us today and what else you could have done in that time. And so I think we're really flattered that you've given us the priority, and we're really pleased. I want you to go back to your mum and dad, though. Teachers, yes? I did, in fact, do some prep on your mum and dad. It was presumably your mum and dad who named you. And so I thought I would just educate the audience about Phoebe, yes?
Mm-hmm.
Greek goddess, one of the Titans, yes? The grandmother of Apollo and Artemis. Her epithet meant gold-crowned, but Phoebe, and your parents must have known this, meant bright intellect. And that's what it means in Greek, and that's the connotation that the word brings with you. She became the third woman ever, female goddess, to run the oracle at Delphi. No pressure, Phoebe, but there you go. And in mythology, she identified with the moon and with Artemis. It's generally a fantastic name to have come into the world with, is what I'm saying. And so all you've really done is live up to their vision. But you've done it okay so far. So thank you very much indeed for coming.
Thank you. Can I give you So I was named for my aunt.
Oh, you're right. Okay.
A much-loved girl who was a medical student at the University of Makerere who died in a cycling accident.
Okay.
So in one sense, I grew up knowing that there was this much-loved human being. So there was pressure. Well, I don't think there was pressure, but it was, as I grew older, there was a period when I resented it because you just want to be yourself. You don't want the never-ending comparison and the much-mourned and much-loved girl. So, yeah.